that he do not want to continue with his directorship and he wants to relinquish all his rights, liabilities and duties arising with respect to the office of directorship.
Excuse me. Once again, I am sorry for inconvenience caused to you. But supposing he tendered the resignation, not accepted, will he continue as a director or not?
No,
If he how? Where is the provision of deeming clause? That's why I put the question. If there is the provision of deeming clause, then certainly he deemed to have been retired, no doubt. But if it is not there, then the whatever act, deed he did during this period, who will be responsible for that? Would he be responsible or not?
No,
Because the resignation is not accepted. There is no deeming clause. He would continue as a member of that team, whatever it is. Then
Lordship, we have catena of judgments in which the Supreme Court itself has said that by only tendering a notice to the company, the designing director will deem to be resigned from his
deeming
office.
clause is there, na?
Yes,
That's what I am asking time and again. If there is the deeming clause, he would be out.
Yes, Lordship.
If it is not, then in.
Yes, Lordship, then he will be liable if
So
there will
say
be not.
there is the deeming clause, so he would be deemed retired.
Yes,
So
Lordship.
say that.
You must specifically advance this argument. My learned brother wants to convey to you that if it is a deeming clause, then you must specifically put
Yes.
force in your arguments on that point. One more point from my side is, what about DR 12 form? What is the significance of not conveying this form?
Lordship, DR form is considered to be a very crucial form as per the provisions of corporation.
What is the purpose behind it?
Lordship, this particular form is used to intimate the registrar of the company regarding
Not only registrar of the company, but also the public at large, because he has to be placed on the website.
Yes,
He
Lordship.
cannot hold out after that as the director of the company. So therefore, it's notice to the public.
Yes.
Beware, don't deal with this man now.
Thank you for your assistance, Lordship. When it comes to the DR 12 form, it is used to intimate the registrar and the public at large to regarding any appointment, resignation and change in designation of directors of the company. Lordship, when it comes to the section 168 of Corporation Establishment Act, it reads as, a director may resign from his office by giving a notice in writing to the company, and the board shall on receipt of such notice take note of the same, and the company shall intimate the registrar in such manner. So it is the duty of the company to fill the required form, not on the resigning director himself. Also, Lordship, as per rules 15 of the corporation companies qualification and appointment rules of 2014, rule 15 says that it is the duty of the company shall file the DR 12 form within the 30 days when he got the notice of resignation by the director himself. Lordship, in the case of SS Lakshmana Pillai versus Registrar of Company and Others 1997, it was held by the court that the notice of resignation was sufficient for a valid resignation, and that resignation take effects only from the date of acceptance by the board of directors. Lordship, when it shall I proceed?
Just a minute.
Lordship, when it comes to my second point of contention with regard to corporate insolvency resolution process, the fact number 6 of the Moot proposition clearly says that Mr. D'Souza has tendered his resignation because he has to look after his Molgar Real Estate Private Limited, which was going through corporate insolvency resolution process. And Lordship, as per various provisions of banking and insolvency law, a person who is insolvent cannot be given the responsibility of directorship. Also, Lordship, as per section 14 of the IBC Code of 2016, it is mentioned that no suit and proceeding shall be instituted against a person who is going through the corporate insolvency resolution process. And also the administration, overseeing of the administration of both the SPVships were given to the Mr. D'Souza without his consent. It arises no liability on the part of Mr. D'Souza. Shall I proceed?
Yes.
Much obliged.
Just a minute. don't you find any distinction between the insolvency of a person and the insolvency of a private limited company? What's your take on that?
Lordship, insolvency of a person means कि if any particular person who is an investor in the company is subsequently declared as insolvent because he has some debts remaining behind him, and the company is something when company is liable against any other company for any debts.
So it was not Mr. D'Souza who was going to be insolvent. Rather, it was his company, Volga Real Estate Private Limited, which was under the process of insolvency resolution.
Lordship, Mr. D'Souza.
These are different aspect and these are two different legal persona.
You see, this para 6.
Yes, Lordship, in the
Just see the facts. Para 6 says that in a subsequent board meeting, Mr. D'Souza tendered his resignation, citing his need for time to see the operations of his company, Volga Real Estate Private Limited, which was going through the corporate insolvency resolution process. And additionally, it was decided by the company directors that Mr. D'Souza would oversee the administration of ships, vessels bearing the name this. Now, what was under the insolvency was the company,
Yes,
not
Lord.
individual Mr. D'Souza.
yes, Lordship.
So, therefore, two companies, in one company he is a director, other company is going through the insolvency proceedings. Would that be a bar for bringing a case against Mr. D'Souza?
Apologies, Lordship, I'm not aware about this provision.
Pardon?
Sorry.
What did you say?
Apologies, Lordship, I'm not aware about this provision
Okay.
in the IBC code.
Okay.
All right.
Now may I, on your point number 2.1 of this booklet, they use the word as Mr. D'Souza is liable under such and such, which state that dash, right? Whether other persons who were part and parcel of that connivance are liable or not.
Thank you for your question, Lordship. First of all, this point will be contended by my co-counsel that how other two directors are not liable under the provisions of AOT Act. Specifically, the medical exception should be given to us as we are a pharmaceutical company, and there is a gross error, the gross lapses made on the procedural aspect of this case that will be dealt by my co-counsel.
Right.
Okay.
So you want to convince fact that all are responsible. If they are in connivance, whosoever may be, all are held liable.
Lordship, they will be held liable, but we will be contending on the part that they are not liable because Mr. D'Souza.
I understand that. I am putting a question indirectly, directly to other side also. They have to reply. I know that, so that they can prepare. If this may come, what would be the reply? So the thorough preparation would be there during this period. That's a very good question. And that is there.
Joint liability.
Joint liability.
Yes, Lordship.
And
Vicarious liability. Joint
vicarious
liability.
liability. And particularly when Mr. D'Souza was assigned the responsibility of SPV's operations. So he is directly involved in the business of the company.
Lordship, he has tendered his resignation before giving.
There are two aspects of the question. One is as a director. Second is as the person overall in charge of the ships.
Maybe manager or maybe in any
Whatever name,
capacity.
because name doesn't matter.
Because if you look at section 38, it doesn't talk about director. It talks about person in authority to take decisions. Have a look at 38 if you have a copy of the Barrett with you.
Yes, Lordship, as per section 38 of AOT Act, if any offence is committed by the company,
Responsible officer.
responsible for any act, its directors or officers in charge will be held liable for the same. But we have in Catena of judgment in which the Supreme Court itself held that only a person who is in charge of day-to-day affairs of the company can be held liable under the vicarious liability of Section 38 of AOD Act. Lordship, in the case of SMS Pharmaceuticals Limited versus Neeta Bhalla and another 2005 Supreme Court, it was held merely because a person is a director or holding any position of a company, it is not necessary that he is aware about the day-to-day functioning of the company. In this case, Mr. D'Souza, who was a director of a company and also subsequently resigned from his post, the basic intention of giving the resignation is that he wants to relinquish all his rights, duties and liabilities arising with respect to the office of directorship. Lordship, the overseeing of administration of both the SPVship were assigned to Mr. D'Souza only because he was a part of the company, he was a director. Once he has tendered his resignation with regard to his directorship, he will be deemed to relinquishing all his rights arising out of his directorship. Also, Lordship, in the case of State of Haryana versus Brijlal Mittal 1998, it was held by the court that for making director liable, it must be proved that the offence has been committed with the consent and connivance of the director. And Lordship, here I have mentioned earlier that there is no consent behind the taking the responsibility of both the administration of both the SPVships, and there is no connivance also of Mr. D'Souza with regard to the same.
What is your take on the punishment of 8 years? Is that legally sustainable punishment or not?
Lordship, as per the provisions of AOD Act, in contravention related to psychotropic substances, person can be given an imprisonment of 10 years up to 20 years. But
10 years means what? Minimum punishment?
10 years, Lordship.
Minimum.
It is 10 years, Lordship.
So where is the 8 years fitting into the scheme of
देखिए
Lordship, it is up
इसमें
to the
पहले से
discretion of the Lordship.
it is amendment
It's the less than minimum.
Lordship, it is completely up to the discretion of the Lordship. And also, Lordship, we are a pharmaceutical company. We are dealing with the drugs and psychotropic substances. We have been granted all the licenses with regard to that. And how this procedural lapses has been made by the trial court as well as the high court, that will be established in our further contentions.
Correct. Go ahead.
सर ये मैं पूछना चाहता हूँ इसमें ड्यूटी हमारे और बट है नो मेंशन चार्ज जिसको भी पकड़ने के तो अदर ऑफिसर में so many officers
This is what I said. When you look at 38, 38 has a very wide such officers.
So you are addressing us on the issue of jurisdiction as well.
Yes, Lordship.
Right. What are your contentions on that?
Lordship, as per the international law and the municipal law, the jurisdiction of coastal state is limited with respect to the contiguous zone. The country can exercise its jurisdiction with regard to enforcement of only customs law, fiscal law, immigration law and the sanitation law, not other matters.
But one of your ship was within the territorial jurisdiction of state of indices and another one was out of it.
Yes, Lord.
So don't they make a comprehensive, because it was a one consolidated business operation. You are claiming that only one ship was held liable, second ship cannot be held liable because it was outside the territorial jurisdiction. Now how do you come out of this argument?
Thank you for your question, Lordship. That's what we are seeking from this court, and we have approached this honorable court under the SLP because a gross error has been made by the High Court as well as trial court by conducting both the SPV ships together, since the fact is there that the courts of indices have jurisdiction with regard to one ship only, not with regard to the other ship.
Who will deal with the second? Suppose we accept your argument. What is the forum where this jurisdiction lies? In respect of the ship which you say is not within the jurisdiction of the courts.
Lordship, the honorable courts have the jurisdiction to try. They can try the offence if all the procedural formalities have been complied with. As
Okay.
I have mentioned earlier, as per section 4C of the AOT Act, if the central government can take assistance from the international authorities if anywhere required, if that has been done by the central government, then the courts of indices have the jurisdiction and then they can try the offence.
All right.
But here the procedural formalities has not been complied with.
Your case is due process has not been followed.
Yes, yes, Lordship.
I'm having a item number 17, right? It is very specific in respect of liabilities, libel under section 38(2), right? It specifies that director, manager, secretary or other officer of the company may be held liable. Now my question is, when you have specified 3 designations, why not other officer? What do you mean by other officer? There are 50 officers in one company, so you may pick up any. Or officer was of that who is responsible. What do you mean by that? In charge, officer who was in charge in absence of all three. If they were not there, then the officer who is holding the charge for even timing, if something has happened, then he will be responsible for all officers as used in the term, whether it is correct or it requires consideration.
Agreed, Lordship. The section 38 says that if any offence is committed by the company, its officer in charge will be held liable.
But here it is lacking. In charge word.
Lordship, when it comes to the officers in charge,
You are right. Exactly, only and only officer in charge in absence of all 3, he would be responsible. But so far as this booklet is concerned, you have mentioned other officers, not officer in charge in absence of all these 3. So that may create the problem for other officers.
But that is part of the section itself. See, any director, manager, secretary, or other officers.
Also required amendment.
It is
You are right, you have taken from the section. What we want to convey is that even the language used in this section is not proper. It should be officer in charge. They have not used word in charge, other officer. So under deeming clause or by presumption, we draw the presumption meaning there were other officer means the other officers who are having the charge for these as they are belonging to A, B, C, D, manager, director and all that. It should be clear, but it is not. But it is under deeming clause, you are to argue in that way.
Lordship, for making any person vicariously liable under
I
this.
think what the section is broadly worded, you have to apply the rule of ejusdem generis or nociter sauces, because any word which is of wider import has to be read in the context of the words which precede it. So therefore it is an officer who is performing similar functions. So therefore that interpretation is provided we agree that he was
We
an
agree.
officer
But it should be
falling
more
in
clear.
other persons, officers, then only he can come into this.
Yes, agreed, Lordship. Shall I proceed?
Yeah.
Lordship, after stating all the facts and the laws, provisions of law, this arises no liability on the part of Mr. D'Souza, and I, counsel on behalf of the petitioner, would humbly request the court to set aside all the convictions made against Mr. D'Souza and set aside the judgment passed by the High Court. With this, please the court, I rest my arguments.
Nice. Sir.
Good afternoon, Lordship. This is Council number 2.
Council number 2.
Good afternoon, Lordship. This is Council number 2 on behalf of petitioner, and I will be contending on issue number 3 and issue number 4. Issue number 3 is whether other 2 directors are liable under the provision of AOD Act or not. Lordship, while contending with this issue, it is very basic question for before this honorable bench is, what about the other two directors? It is very basic question. Lordship, I will be contending on 5 main grounds to establish the innocence of other two directors. The day of 10 January 2023 was not valid. Is mentioned from the proposition. Number 3, the medical and the scientific exception must be given to the petitioner under section 8 proviso. Number 4, under the benefit must be given under drugs and the cosmetic rule 1945. Number 5, what is the matter under AOD section number 38? Well, starting with the first provision, that there was no proper search and the seizure. Lordship, the section number 42, clause 1 and 2 says that, of AOD Act says that, it's a clear power given to any kind of officer, whether revenue, narcotics, and all of the central officers to go for any building, conveyance, and any transportation, and he can make any kind of search and seizure. But Lordship, he can make when he can make the search and seizure after the sunrise and before the sunset. He is when the search is made after the sunset and before the sunrise, then the special reason need to be given to the superior officer sitting to him. Lordship, under section number 42, clause 2 says that whenever an arrest is made by any designated officer on his own knowledge or upon the knowledge given to him by another person, then that particular information need to be given to the superior officer within the 48 hours. Lordship, in the present case, there is not even a single mention that what was the timing of the search and the seizure, and what was the relevance of the information given to the central excise officer of the prosecution. And how did he make the arrest? This makes the arrest doubtful. Lordship, the second point is the section number 50, section number 55, and section number 57 of AOD Act says that whenever an arrest is made under the AOD Provision Act, under section number 55, it is clearly written that the affixation of the seal is need to be made by any police officer or police station which is near to the which is in proximity to the officer who has made any search and seizure. Lordship, the section number 57 says that all of the sampling reports while making the arrest need to be in the very concise details. Lordship, if there are failures of section number 42, 55 and 57, the landmark case of Supreme Court of India, Thandiram versus State of Haryana 2000, Kishan Chand versus State of Haryana 2009, and Santini Simon versus Custom Department 2021. In all of these judgments, Supreme Court said that if the section number 55 and the 57 have not been compiled with, the sampling and the search report is missing, then we will turn the acquittal into the conviction or either grant the bail at the very first instance. Lordship, the second point.
Yes, hold on. Queries to you. What was the location of the vessel when the contraband was seized?
Lordship, the location was 18.5 kilometer for first ship, and the second location was 35.5 kilometer.
So do you suppose that all the procedural requirements to be fulfilled were practically possible to be complied with?
Thank you for your question. Lordship, when we are saying the arrest was made at 35.5 kilometer, which was outside the jurisdiction, which my counsel number 1 contended, Lordship, it becomes very inevitable on the part of central excise officer who is not given the power.
Vessel was bearing the flag of the jurisdiction of indices.
Lordship, as my counsel once stated that when we come to, it's a very common question, how can we say that it is outside the jurisdiction? Lordship, thing we are contending is one ship is within the territorial waters and one ship is in the contiguous zone. All of the entities which has the extraterritorial provisions and all of the criminal act says that the government can do so. But Lordship, my counsel contended that under the section number 51, it is clearly mentioned that whenever any seizure, search, arrest is made, you have to comply with the CRPC procedure. In the Narcotics Act, where the seizure procedure and the procedures are missing, we rely upon the procedure of CRPC. CRPC section 188 says that if you want to conduct are petitioners on the basis that jurisdiction was and on the complete jurisdiction we are convicting you. But for this gross mistake, we relied upon this gross mistake and to the Supreme Court of India. Also, coming to the second point, no FSL and
With your permission. You say that the other ship was outside the territorial jurisdiction. Still they caught it and registered the case. Right? It is your argument. Whether they write the distance or measurement from where they have taken away that ship or at which point they have caught it. If it is not, then what would happen?
if the ships would have been caught on that very particular day within the jurisdiction, then
Within the jurisdiction, okay.
within the jurisdiction.
If it is not written that we caught this ship at this place, then what would happen? Sometime it is left, you know it. Sometime it is written for the reasons best known to them. If it is not written nearby, then what would happen? Tell me.
It would have not been written. It would be lack of the part of the moot proposition only. We would have contended that due to lack of listing on the moot proposition in the fact sheet only. We don't have any accurate data on which we can contend for the jurisdiction.
So there is a chances of non-commencement of any criminal case against them.
Lordship, if this would have been the situation where the jurisdiction would not have mentioned and it was within the jurisdiction,
Then
we
okay.
would have.
Then okay.
There's no mention of that. It was within the outside or outside of jurisdiction. We would have said that the person will be held guilty for that. But Lordship, what I am contending before this honorable court is the search and the seizure has not been compiled in the present case.
Okay. That's one part. We don't dispute that. I put this question for a specific reason. If it is not, then what would be your defense? Tell me.
A defense would be.
Tell us, not me. sorry,
Our
sir.
defense would be if anything would not have been mentioned on that very particular day, as it was seized, all of these salt seized in the quantity of 500 gram, 500 gram methyl isobenzolglycoside. Second acid is phenyl cyclohexamine, and the third acid is barbituric acid. Lordship, all of these acids, as we are mentioning ourselves, are the prohibited item under the Schedule 1, as well as the Schedule 1.
There is no dispute about that.
We are not disputing that.
Lordship,
His question is varying something else. Suppose there was not mentioned in any document the place, the distance from where the ship was seized. And then in that case, what will be the arguments from your side?
Lordship, the argument would be as this is a pharmaceutical company, we under section number 8 proviso have a medical and a scientific exception. Lordship, when the medical and a scientific exception is granted to us, we are accepting that we have a medical and scientific exception, and we can, in the fact number 1, it is clearly written that the company was incorporated in 2015. Lordship, it is very implied in all of the senses, the sense that all of the licenses have been compiled at that time in 2015. Now, it is clearly mentioned that there is no jurisdiction. You have stated that no mention of jurisdiction. And what if all of the assets in the ship have been seized? Lordship, we are saying that we are in normal course of a daily-to-daily drugs basis, which are also dangerous. Lordship, but we have a license in which we can sell license from one place to another place in a specified quantity. But under this proposition, we are saying due to a lack of search and seizure compliances, the samples could have been altered with. The samples could have been misplaced by anyone. That is why we are demanding that due to search and seizure, this makes the time initiated.
How can you say that the search and seizure was not made as per the procedure?
Lordship, in the fact number 8 of the Moot proposition, it is clearly written excise inspector make the arrest. After that, there is not even a single mention what was the time of the arrest, what was, is there any sampling report, is there any FSL report. All of these judgments, whether Balbir Singh versus State of Punjab, secondly Thanari Ram versus State of Haryana, all of these judgments clearly mentioned that the FSL and chemical report 55 and 57 have its own relevance. If all of these things are missing, this makes the trial automatically vitiated, or we will grant up acquittal on the very premises.
So
Yes,
meaning
proceed,
thereby, just a minute, just a minute, please. So meaning thereby you want to convey that if there is no mentioning, then it would be deemed that that is within the Indian radius. So no offence. So bail should be granted, right?
It would be offence. It would be offence because
Offence for that particular purpose, international. If you are within, because there is no mention anywhere from which place your trip was caught. If it is lacking, then you will say, I'm in India and it is valid. And whatever offence I committed, that has to be dealt with accordingly. If I deserve the bail, I should be granted.
Lordship, yes, we would have been convicted for the same amount which was seized on the very particular day. But we are saying, we are contending, although we are giving the medical and the scientific exception, but what we are saying is, if there is absence of FSL, chemical, 55, 57, 50, the procedure aspect need to be followed by the prosecution officer on the very particular day. So how can this make a trial, a total valid trial on the very particular day? Lordship, shall I proceed with my Lordship, the second point is that no FSL in the chemical report under notification, central government in the notification of 74 F 50 clause 53 slash 54. The central government of India made a notification to all of the central revenue laboratories that a FSL and the chemical report, whenever a seizure is made in a NDPS Act, the seizure is a primary material evidence, and to convert the primary material evidence into a conclusive evidence, a chemical and the FSL report is very mandatory required. In the cases of Vinay Kumar versus State of Haryana, Ajit Singh versus State of Haryana, and Sushil Kumar versus State of Haryana 2021, in all of these cases where the chemical and the FSL reports were missing, either the bail was granted or the acquittal was granted on the very first day. Lordship,
But in clarifications clauses, in 54, did the inspector from Department of Central Excise have a valid search and seizure warrant for the SVP? Yes. Was the search and seizure conducted following proper legal procedures, including the presence of witnesses and documentation of evidence? Yes. All the clarifications are there. So I think you didn't go through these clarifications before arguing.
Have you got this?
This is, I think we don't have.
Might have been provided these clarifications on these points.
Okay, Lordship, it has been compiled. And next point is the medical and the scientific exception. Lordship, in the medical and scientific exception, under section number 8C, section number 12 of the AMC says that whoever in contravention of narcotics and the prohibited items have a valid license and a medical and the scientific exception can be granted to those persons. Lordship, we are saying that on the very particular day, if we start with the fact number 1 of the proposition and fact number 2 of the proposition, it is clearly written that this is a company which was incorporated in 2015. Lordship, whether in 2015 when it was incorporated, and the fact number 2 says that this is The company which deals in the APIs of various therapeutic segments in neurology, antidepressant, DMARD, diabetics, and all of the things. Now coming to the decoding of the acid, the first acid is the methyl ester benzoyl ecogenine. Lordship, the first acid, methyl ester benzoyl ecogenine, is a derivative of a cocaine. Lordship, this very particular acid, as per the report of the forensic toxicology we have mentioned in our memorial, says that if this acid can be used for the process of the gas chromatography. We accept that, although we cannot use for the medical exception, other alternatives are available, but under the scientific exception, some view need to be taken into the consideration of. Lordship, the second acid is phenylcyclohexylamine, which is a derivative of phencylidyne, is a salt which is used for geriatrics, obstetrics, and many kind of other health hazards. Number third acid is diethyl barbituric acid. Lordship, this acid is used for central nervous system and various problems of anxiety, insomnia, and other kind of things. Now, if we link the chain of all of these acids and all of the therapeutic segments mentioned in the fact number 2, it is directly making a connection between all of these things at some of the extent. Lordship, we are saying that as a medical scientific exception, it's a daily course on a manufacturing company when we are having therapeutic segments in a various segments makes some sort of relation, and hence the exception must be granted to us.
Under what provision of law you are seeking this exception?
Lordship, under section 8 proviso to section 8 of AOD Act 1985.
Section 8.
Section 8. Have you considered the quantity seized?
Lordship, we consider.
Is there any reference to the quantity also in the proviso?
Lordship, yes, we are supposed to be in compilation of the provisions that whenever a license is granted to us, then we are supposed to be in a specified limitations and the specified quantity need to be produced by us. Lordship, but the thing is, when we have mentioned for first provisions of search, seizure, compilations, and the no vessel in the chemical reports as per the fact sheet of the Moot proposition, we are saying that what if on the very particular day the evidence could have been altered by any person of who made an arrest by the central excise officer who made an arrest on the very particular day.
Your argument is not that the quantity that was seized was prohibited quantity.
Lordship, we are contending for that it is a prohibited item. It is a prohibited item, and the quantity was seized.
And you say only because the procedure was not properly followed.
Gross mistake in the procedure. Gross mistake in the procedure. That's why we are filing SNP before the Supreme Court of India.
Sir, with your permission, वो तो आ रहा है, ये इस पे पूछता है. Which proviso? Detail बाद में सर.
Lordship, section 8 proviso to section 8.
There are 3 provisos.
Lordship,
Yes.
8C. Lordship, 8C.
Dear friend, sir, with your permission, sir, I would like to, with the permission of all of you, if you whether you can acquire the properties, monetary or otherwise, out of the business of contraband materials, can you legally acquire it, or is prohibited?
Whether quantity is meaningful in contraband items.
That is it.
Lordship, pardon Lordship, I am unable to understand this.
Ma-
In relation to property.
In relation to the property, supposing you are in that business, unauthorized business, in other words, I would like to say,
Lordship.
under license you do it for a particular quality, quantity, license is granted, I do agree. But if you do beyond that and acquire the properties, can you legally acquire or can you show that? Then you have to show the total accounts.
Lordship, we can't acquire that if the.
So you cannot acquire now?
Lordship.
You are right.
Yeah, we
Under which section?
Lordship, sorry.
8A,
8A.
right?
Reading minutes for that same regard.
So it is prohibitory. You cannot acquire the properties out of the
Lordship, but
money you earn through illegal means. That is illegal mean because that is not permitted beyond limit.
Lordship.
Good.
Lordship, the fifth point of the contention of issue 3 is AOD provision section 38. Lordship, the proviso to section 38 says that, as it is clearly mentioned, that directors, officer in charge or any person will be held guilty for the same, all of the things, which is contravention of narcotics and psychotropic substances. Lordship, but the proviso says that a spatial knowledge, the requirement is the person must have a knowledge or due diligence must be shown if by the prosecution as a standard proof of burden, then only we can be convicted for the same. Lordship, but when we come to the respondent statements and the facts of the respondent, they say that knowledge can be directly linked to the directors. But Lordship, what we are saying is, on the part of knowledge, there is not a single mention that on the very particular day whether what kind of duties they were assigned, what kind of duty, if they assigned the duties, they were in direct responsible charge of the very particular day in designating all of these things, whether they have a proper knowledge.
This is very much there in the proposition. He was in charge.
Lordship, they were in charge of that, of the same thing. But Lordship, the knowledge cannot be proved, as we are saying.
What knowledge are you talking about?
Lordship, the knowledge is
knowledge of the consequences, not knowledge of the fact.
Lordship.
When we talk about knowledge as a ministry of you, and then the fact that is stated also there is due diligence.
Lordship.
Now, what is due diligence? Have they done that due diligence?
The most important thing of main series is the actual conscience must have been shown. Lordship, in the present case, only the delegation was made by the directors, and after the crime was transpired on a very particular day.
But is it not the duty of the directors to ensure that what is being transported in
Lordship.
is something which is not prohibited quantity?
Lordship, for the very same thing I contended in my first point. Whenever it comes to the search and the seizure and the medical exception, we are saying that we have a knowledge that we are trading in the medical and the scientific exception. But what we are saying that if on the very particular day, since 2015, we are in the regular course of pharmaceutical. But on the 2023, when the search and the seizure is made of the items which were more than prohibited quantity, we are convicted for the same. Lordship, since 2015, it shows that the gap shows that we were in a regular course of all of the items on the very particular day. But the Lordship, in 2023, when the seizure was made and the conviction was made, we are just making the exception in the same regard that we have a medical licenses. Firstly, the search and the seizure samples were not compiled with. In the same regard, we say that the trial need to be vitiated. Lordship, shall I proceed with my
Yes.
issue 4? Lordship, when we talk about whether the company is liable under the AOD Provision Act or not, we have a Lordship provision of separate legal entity and corporate veil. The first landmark case in regard to this is Salmon versus Salmon. Lordship, the Salmon versus Salmon says that whenever a company is designated, it becomes an artificial person under section number 2 and 11 of IPC. Whenever it becomes an artificial person, so it has its own legal entity. When we are talking in the issue number 3 and contended in issue number 2, when the directors are not liable in put forth contention of us, then it cannot make the company also liable in the same regard to that. The corporate veil, the state of Uttar Pradesh versus Renu Sagar made a distinction that first of all, a corporate veil is that veil which distinguish between the innocent person and the person who are in actual malice. In the present case, we are contending that the person of the company are the genuine person, are the person who have been falsely implicated. This at last makes the company also innocent in the same regard. And Lordship, if your Lordship is pleased with my argument, shall I plead the prayer?
Before
Prayer
you go
we
to
know.
that prayer,
Lordship, section number 38, for which I have
It
contended
specifically provides for the company's prosecution.
that, Lordship,
38. Independent of the directors, company can also be liable.
liable.
That is
Company
right.
is a juristic person being
Company.
registered under Companies Act.
Lordship.
Once it is a juristic person, then
Lordship, for this we have contended that if a pharmaceutical company was incorporated in 2015,
Kindly read the section 38. It says all those people in charge
one charge.
yes,
and also as well the company shall be deemed to be guilty of the offence and shall be
Exactly.
proceeded against and punished accordingly.
Lordship, for the same thing, if the contentions we have made for the directors, that all of the contentions of search and seizure, sampling reports, in the same manner we have proved the innocence of the director. In the same manner we are contending for the innocence of the company. Hence the section we are pleading for the exemption under the section number 38 also in the same regard, where the innocence of the directors is being pleaded in the issue number 3 and 2. but on the same grounds and instances we are pleading for innocence in the, for this Company Act also.
By the trial court or by high court, the company was not convicted previously. But otherwise company is liable to convict.
So companies are liable to be convicted, and all of the contentions have been also made, and issues also is regard to that.
Section 38 is very clear. Read again. Last 4 lines.
Yeah, yeah.
Read what I am reading with your permission. May I read it? Where an offence under Chapter 4 has been committed by a company, then comma, not continuation. Got my point? Every person, again comma, who, again comma, at the time of offence was committed was in charge of, comma, and was responsible to, that is very important, comma, to whom? The company, to हो गया अलग, the company for the conduct of the business of the company as well as company shall be dealt. So company word used twice in different synonyms, right? So company is also liable or not?
Lordship, for the contention of the company is
He
liable or
says
not.
that
Lordship, this is the
bringing
same
the exception
issue for the
cases
issue number
innocence of
3,
the company.
where the
Innocence
directors are not
company.
liable. We have stated that if the directors are also not liable for the same
But
grounds.
you were arguing, other counsel said you will be arguing on jointness of the liability, but we have not heard the argument on jointness of the liability.
Lordship, for the vicarious.
Yes.
Lordship, for the vicarious.
How do we say vicarious liability of all the directors?
Lordship, the landmark case of the SK Oja versus VK Vora, Supreme Court clarified the instances that if you want to put the vicarious liability, there are 2 factors. The first person must be responsible for that, factually responsible for that. Second, the person must be legally responsible for that. Lordship, the 4th factor says that factually responsible are those person who are the actual designated directors or the person who are making the signatures and non-executive directors and many other persons. But Lordship, when we come to the legal responsible factor, it must be proved by the prosecution that the link must be established that actually it was done within the purview of that person or a director, then only the vicarious liability can be put in. Lordship, but when we are contending in the issue number 3, where the search seizure sample FSL report is missing, all of these things missing, makes the trial vitiated. Hence, all of, in the same thing, how can the vicarious liability can be imputed on all of the directors as well as the company?
Have you gone through this clarification 29, Moot proposition, para number 3, whether the decision, production and distribution of stocks only with the signature and approval of all the 3 shareholders, including Mr. D'Souza, was meant to be clause in article of association of the company? Yes.
This clarification was provided to all the contestants.
Clarification were provided, but we are contending on the same ground for the
Clarifications are for the variance and this person. And very important clarifications are there. And you take go through that unnecessarily arguing on those points which are very much clear in this clarification.
Gentlemen, in the course of your arguments, you made a very interesting and sweeping remark when you were talking about lack of statutory compliances. And you made a mention about certain judgments in which bail and acquittal was granted on the same day. It's very startling for us to even hear this, that bail and acquittal are granted on same day. Would you please enlighten us with the authority?
Lordship, we are saying that the section number 55 and the 57 says that whenever...
We are not about the mechanics of your argument. What I am saying is you are stating that there are cases to the effect when there was a lack of statutory compliances, bail was granted and acquittal was granted on the same day. So from where did you derive this argument? We are not going on the merits of the case. I am very keen to know those judgments actually.
Lordship,
Wherein bail and acquittal are granted on the same date. Please enlighten me.
Lordship, it is not on the same day but on the same premise.
Your argument, that's why I noted down. Your argument was bail and acquittal was granted on the first day. So I'm very keen to know.
Lordship, apologies for that, but I
Please
said
don't,
that,
please.
apologies for
Whatever
that.
you say on this August dais, that is taken as gospel truth. So don't take these liberties. You also please note it down. Everything is being noted down.
Lordship,
So there is no case when bail and acquittal is granted on the first day.
first day, Lordship, yes. It needs to be
Strange.
accepted by the premises of the section 55 and the 57 on
We
the
are not all going on the mechanics of your argument. Your argument is it may have its own merits, it may have its own demerits. We just wish to know where did you derive this hypothesis that bail and acquittal was granted in such and such judgments. You have shown good number of judgments to us. So where are that judgment in which bail and acquittal is on the first day? So you don't have anything. It was only argument in air.
Lordship, not arguing.
Sir, with your permission, with your
Last
permission.
decision, last.
Just a minute, with your permission. So you wanted to convey not only to the dais but also to your colleagues that the trial has been completed on the same day and acquittal has been granted.
That's why I was very curious.
Huh?
It was very
Is it possible?
shocking thing to know.
Is it possible or it is legal?
Lordship,
Exactly.
Tell me, is it possible or it is legal? It is neither possible nor legal. And how can you raise such arguments?
Lordship, apologies in the same regard. Apologies in the same regard. And
should
mark in
never.
consideration of the
So
mark in.
be careful in future.
Okay.
Okay, dear.
With this, I raise my argument. Shall I read the prayer?
Prayer we know.
Wherefore, in the light of issue raised, argument advanced and authority settled, it is humbly prayed before this honorable court to make it please declare that to allow the special invitation for this honorable court to make all of the directors under AOD Probation Act innocent and to make innocent
Not
same
innocent, set aside their conviction.
conviction and to make company also innocent under the AOD Provision Act 1985 and pass any other order, direction, relief that it may deem fit in the interest of justice, equity, fairness and good conscience. Thank you.
Greetings to the honorable bench. The council seeks the motion for procedural.
Please can.
Council seeks permission to address the bench.
एक ही मार्क करे लेकिन discuss.
Please hold on for some time. We'll ask you to initiate your arguments. Just after few
Should we I think we can discuss it because ज़्यादा appreciation and application of facts. 6, 7. You can give 6 or 7 to both. नीचे. Six, 7. उसको भी ऊपर भी दे देना. दो मेंबर्स हैं. टीम के 2 मेंबर. That was better. You can continue with the same pattern 8.
नहीं, तो थोड़ा सुन ले.
हाँ?
इससे किसी ने बैटर किया तो इसको बैटर किया.
किसको?
इससे किसी ने बैटर जिससे बैटर
हाँ चलिए ठीक है.
उसको कॉन्फिडेंस
7, 6 चले. Then we can give to same 2, 7, 6. We can give 7, 6 again.
इसमें अच्छा लगेगा प्रेजेंटेशन इसकी.
Presentation
अच्छा
अच्छा.
है.
We can give her 8. 7 here.
क्रिएटिव थॉट्स इसमें
7.
7 और 6
Yeah.
राइट. ठीक है. 7 institute
7, 6 again. You can give 7, 6 again. 7, you can give 7.
ठीक है ना.
Yes.
Yeah.
please continue.
The council seeks permission to address the bench collectively Yes, Your Lordship.
Your mic is not working, I think.
Excuse me, Mr. Court Master. The time will start now. Right?
The council seeks permission to address the bench collectively as Your Lordships and individually as Your Lordship and Your Ladyship. Much obliged, Your Lordship. The council seeks permission to address the honourable bench with issue 1. Much obliged, Your Lordship.
You can identify also the issue number 1 on which you wish to propound your case. Issue number 1, that is so and so.
Indeed, sir. Issue 1 concerning the jurisdiction of the courts of indices over the SPV ships, Your Lordships. Before the submission, Your Lordships, the council seeks to draw your attention to para 8 of the Moot proposition, wherein in the 4th line it has been mentioned that the ships were registered in indices, Your Lordship. According to section 1 subclause 2, there is express statutory jurisdiction that is granted to the territory of indices over ships that are registered within the country.
1 subclause 2 of,
The AOD Act,
you
apologies.
have to mention it. Act.
Apologies.
Yes. Yeah. Yes.
Section 1 subclause 2 of the AOD Act, para materia to the NDPS Act, grants explicit statutory jurisdiction to ships which are registered in the country of indices irrespective of their location, which can be inferred from wherever they may be. Your Lordships, such jurisdiction that is granted within the statute itself implies that the courts of indices had such jurisdiction to address the trial. Additionally, Your Lordships, the learned counsels for petitioners have said that section 1 subclause 2 has to be read with section 51 of the very same act, which is AOD. Your Lordships, section, may I proceed, Your
Yes.
Lordships? The operative part here is insofar as they are not inconsistent with the provisions of this act. Your Lordships, the counsels for the petitioners have submitted that section 188 CRPC has to be applicable here. However, the maxim of generalia specialibus non-derogant, wherein a special law supersedes the general law, which is also mentioned in section 51 itself, the operative part which says that insofar that they are not inconsistent with the provisions of this act. Therefore, section 188 of CRPC will not be applicable in the present matter. Further, Your Lordships, as the territorial jurisdiction of the ships is concerned, there are two parts to it. May I proceed, Your Lordships?
Just a second.
Yes,
Yeah.
thank you, sir.
Your Lordships, if I may draw your attention to page 15, para 5 of our memorial. There are two aspects. One,
Para 15 of this one,
no, the red memorial.
red one.
Yes.
Page 15. And I must bring it to your notice. Para 15, page number?
Page 15, para 5, Your Lordship.
Para 5.
Page 50.
Page 15,
Para
para
5. Para 5 is last two lines, is it?
Sorry, Your
The
Lordship.
last two lines.
Yes.
Which page?
It is-
Page 15. Page 1.
The jurisdiction of the ships has already been established under the statute. However, the learned counsels for the petitioners have referred to the same act, and herein the council seeks to submit section 3 subclause 2, which covers the ship that was seized at 18.5 kilometers, which is within 12 nautical miles. Secondly, Your Lordship, section 5 is the one which is granting contiguous zone. Subclause 4 of the same act, which is present on para 6, is talking about the right to exercise jurisdiction over fiscal matters, custom matters, and such other matters that have been presented. Your Lordship, this argument that the learned counsels have presented, that the present matter is not applicable in any of these. Your Lordships, the humble submission in the view of the council is that fiscal matters would mean something that is within the Ministry of Finance and Department of Revenue. Your Lordships, Department of Central Excise is constituted under the Ministry of Finance and Revenue. Additionally, this argument is ancillary to the first argument that already statutory jurisdiction has been established by the AOD Act, subclause 2 of section 1, your lordships.
Excuse me, so you want to convey that the whole exercise did by the team was without jurisdiction?
No, your lordship.
It is within jurisdiction, na?
Indeed, yes, your lordship.
Pakka.
Indeed.
Proceed.
Much obliged, your lordship. Your lordship, the council also seeks to submit a precedent of Halliburton offshore services that your lordships may find in the compendium submitted by the councils, and it is there on page 4 of the compendium, your lordships, wherein the courts, may I proceed?
Para 4,
Of the compendium, your lordship.
page 4.
Page 4 of the compendium, your lordship. Apologies, not the memorial. It is there with
This one.
अच्छा ये लिखा है.
page 4 of the compendium, your lordships.
Yes, what is it?
The court in this case has opined that registration of a ship grants nationality to the same, and it is the territory of the country as an extension when the ship is registered, as already has been established in para 8 of the Moot provision, your lordships.
Para 4.
Further,
This is registration.
There is only one set provided.
sorry, your lordship.
There is only one set of the companion which is being
Apologies, your lordship.
Just read, what does it say?
Registration, para 55 of the case says that registration of a ship is a means of bestowing nationality upon the ship, and that it becomes entitled to fly Indian flag and thus is eligible to claim benefits and other such things that are being considered under the act that is there in the present case, your lordship.
There's a bottom something written, registration therefore operates as a bridge between the ships and the mainland and extends nationality rights to the ship.
Indeed.
It serves as a legal institution linking the ship to the state.
Indeed.
So what is your argument?
The submission of the council is in three parts. The first one being the statute. The argument to answer your lordship's question is to justify that the ships had the jurisdiction over the country of indices had the jurisdiction over the ships, your lordship.
Both the ships.
Both
One,
the ships.
they admit that we have the.
Indeed, indeed.
They are only talking about the other ship, which they say is outside the.
Indeed. To answer your lordship's question, the second ship found at 35.5 kilometers,
Yes.
the answer is there in statute AOD Act, section 1 subclause 2, wherein the operative part is wherever they may be.
They say you should read the domestic law in consonance with the international law. That is their argument. How do you deal with this argument?
Indeed, your lordship, the international law of UNCLOs is also the one wherein the Maritime Zones Act is derived from the same law, and therein the section 5 subclause 4 of the contiguous zone is granting jurisdiction for such matters, your lordships.
Now, jurisprudentially, can you tell us what is the object of this legislation?
Jurisprudentially, your lordships, the object of this legislation that is also usually...
No, because I think we did not hear anybody talking about the very purpose of this legislation and consolidation of this law to bring it in conformity with the existing international action against drug menace and trafficking. And therefore, is it because of that reason that 1(2)(a)(b) talks about extending the jurisdiction across, irrespective whether they are in the continental zone or they are not in the continental zone? If it is found anywhere, as long as it's a registered ship in India, you don't have to question the jurisdiction of the Indian courts. Is that your argument?
Indeed, Your Lordship, the two aspects of Your Lordship's question. The first one being that AOD Act with consonance with international law. Even jurisprudentially speaking, in statement of objects and reasons.
That is why nobody talked about it.
Apologies, Your Lordship. If Your Lordship may allow, I will reiterate.
Yes. No, we have read it, but then you should say why this legislation consolidation was necessary. Because it's an international problem, it's a problem across the borders. So therefore you have to have a law which can at least not have the problems relating to the borders.
Apologies, Your Lordship. The Council will take this into consideration.
Yes.
May I
Yes,
proceed,
please.
Your Lordship?
Yeah, please.
Much obliged. Your Lordships, the second aspect that the learned counsel for petitioners have contended is the grounds that warrant the acceptance of the SLP. There are two aspects to it. The first one being the jurisdiction, which has already been submitted by the council as to why the jurisdiction lies. The second aspect of it is the aspect that the trial should be vitiated because there was illegal search, seizure, etc. Your Lordships, there are 4 clarifications in the final clarifications. Clarification number 7, clarification number 54, 56 and 63. May I proceed?
Yeah, please proceed one by one. Which is the first one?
Indeed, Your Lordship.
Point number 4 or 7?
7.
7.
Clarification number 7 of the final clarification says that all procedural compliances by the government have been carried out. Government would include all the, since the Department of Central Excise is within the state, it would include all the compliances. Further to reiterate the details, Your Lordship, clarification number 54, that whether the inspector had valid search and seizure warrant, and the answer to it is yes. Further clarification number 56, that whether search and seizure was conducted following proper legal procedures including presence of witnesses, documentation of evidence. So all the claims as to the FSL reports and all other documentations are answered by this clarification, Your Lordships. Further, clarification number 63 talks about could you clarify the legal process and the chain of custody and were all legal protocols adhered to which the answer is that yes, all the legal procedures have been adhered to. Your Lordships, in light of such facts that are clarified in the final clarifications, the questions raised by the learned counsel for petitioner is not a question of law but a question of fact. If the question would have been that in such case that there has been procedural incompliance, whether the trial can be vitiated or not, then that would have been a question of law. In the present matter, when it is an established fact that all the legal procedures have been adhered to, then there is no law ambiguity in the present case, Your Lordship. Further, to substantiate my argument, Your Lordship, the council seeks to rely on the precedent of Preetham Singh versus the state, Your Lordship. If Your Lordships may please refer to page 7 of the compendium. Sincere apologies that there are just one copy. I will read out the same.
Page
7 of the compendium, Your Lordship.
this is here.
Please tell public 7. Page 7.
The last lines say that this court is not an ordinary court of criminal appeal and will not, generally speaking, allow facts to be reopened, especially when two courts agree in their conclusions with regards to them, which is also a similar case in the
That is
present
the
factual
scope of
matter.
Article 136 is very limited.
Indeed,
It's the
Your
power of the judicial review at the discretion of the Supreme Court itself, where it will lie only in very, very special situations
Indeed,
where a substantial question of law is raised.
indeed.
Disputed questions of fact cannot be gone into when we are dealing with 136 jurisdiction.
Indeed, Your Lordship. That is precisely the submission of the council.
So I
as well.
could see that. Yes.
Your Lordship, page 9 of the compendium is the next part which Your Lordship also stated. The very last highlight, that generally speaking this court will not grant special leave unless it is shown that exceptional and special circumstances exist and that grave
That
and
we know, that we know the scope of the power of 136 we know. If there is a finding, concurrent finding given by the two courts below, Supreme Court should be reluctant to interfere in such kind of matters.
Indeed, your lordships.
Bharat Bank versus the employees of Bharat Bank was the first case which went under 136, talking about the scope of the jurisdiction of the Supreme Court in 136.
Indeed, your lordships, and in light of the same aspects, the submission of the council is that the grounds for filing this SLP have not been fulfilled, your lordships. If your lordships do not have any further questions, the council seeks to proceed to issue 2 concerning Mr. D'Souza's liability. Much obliged, your lordships. Your lordships, before...
So what I conclude from your submission is that we should be governed strictly by section 1(2)(b), and that is also something which is sought to be furthered by the convention, international convention against the drugs trafficking and other things,
Indeed,
right?
your lordship. If the council may humbly seek your lordship's attention to para 3 of the proposition. Before proceeding to the legal aspects of the issue, your lordships, the council seeks to iterate a fact that the stock including pharmaceuticals could only be produced and distributed with the approval and signatures of all 3 shareholders, including Mr. Quentin D'Souza. This iterates that Mr. D'Souza is a signatory authority to the production and distribution of the pharmaceuticals.
But the change shifts in 2019. See, these are the facts which are initial facts. If you go to para 5, there's a difference developing among us, the promoters and this inducted director, as a result of which at some point of time he decides to leave the directorship. So therefore that's a change in the facts what you are narrating in para 3.
If I may seek your lordship's attention to para 9 of the proposition. The proposition says that Mr. D'Souza has resigned from the directorship of the company, your lordships. It is
Para, which para?
Para 9, 4th
Para
line.
says the D'Souza and other directors charged under the applicable and relevant provisions of the corporation establishment and this act pleads innocence, stating that he has resigned.
Indeed, your lordships. From here, para 9, 4th line, resigned from the directorship is the material words here.
Yes.
So, whereas in para 3, it is talking about the rights conferred to him as a shareholder.
Right.
So, there is a difference between the two. He may have resigned as a director, which the council will further be arguing as to why such resignation.
So he continues to be the shareholder of the company.
Indeed, your lordship, and therefore he is a signatory authority to the production and distribution. This material fact is the basis of establishing the prima facie case for mens rea of Mr. D'Souza, your lordships. Further, your lordships, there is a presumption of culpability under section 35 that is going to be there on Mr. D'Souza, and it has to be proved by Mr. D'Souza as to why he did not possess the knowledge. Your lordship, the council seeks to rely on section 2 subclause 27 of the Companies Act, which is paramateria to the Corporate Establishment Act.
2
subclause 27, your lordship.
Section 2.
Section 2, yes, your lordship.
control.
Yes, your lordship. The further aspect of Mr. D'Souza's liability will be based on the premise of control. Control shall include, the second line is material to us, to control the management or policy decisions exercisable by a person by virtue of their shareholding or management rights, your lordship. Herein, para 6 of the
So as a shareholder also, if he has a control, your point is that it is a control within the meaning of section 38.
Your Lordship, para 3 of the proposition has to be read with para 6 of the proposition, wherein it says that additionally it was decided by the company's directors that Mr. D'Souza would oversee the administration of the ships, Your Lordships. Therefore, Mr. D'Souza has the control over the ships, Your Lordship. So, two aspects of why he possesses mens rea. The first one is in his capacity as a shareholder, he is a signatory authority. And second is the premise of control test, wherein Mr. D'Souza has control over the ships that has been conferred as per para 6 of the proposition, Your Lordships. Further, Your Lordships, Mr. D'Souza...
Does it mean that every shareholder should, since he has some control, therefore they will fall in the definition of control?
No, Your Lordship, we do not, the council does not seek to submit that every shareholder will be liable for the offences. Both these things...
His query is very specific. He wants to know that whether every shareholder is entitled to have the control.
could you please repeat your question, Your
Will
Lordship?
merely because I am a shareholder, should I also come within the definition of control within the meaning of subclass 27?
Your Lordship, there are two aspects, shareholding rights and management rights.
Correct.
So if a person has shareholding rights to control something, then that person would be liable. However, every shareholder is not liable. So the control aspect that the council seeks to submit is in light of his administrative capacity as well, Your Lordship, which can be seen in para 6 of the proposition. Your Lordships, the counsels for the petitioners have iterated that at the time of the offence, Mr. D'Souza was not in control. Your Lordships, this argument can be refuted by the fact of para 6, and the material word is additionally. So irrespective of the fact that whether or not he was a director, which is a subsequent question as to whether his DIR 12 form in compliance will hold validity or not, he will be held liable because of his role as an administrator of the ships, Your Lordship.
Controller.
Sorry, Your Lordship.
Controller, rather in other words.
Indeed, Your
All right.
Lordship.
Go ahead.
Much appreciated.
Just a question to you.
Indeed.
Assuming that he was in control of the affairs, assuming that he was as a shareholder controlling the matters relating to the drugs, I want to attract your attention to clause 2, section 38 of NDPS, AOD Act.
Please allow me a moment, Your Lordship. Yes, Your Lordship.
Notwithstanding anything contained in subsection 1, where any offence in the chapter 4 has been committed by a company and it is proved that the offence has been committed, now I need your attention, with the consent or connivance or is attributable to any neglect on the part of any director, manager, secretary or other. So
File.
Red one.
that will be done.
Okay. Which page?
Page 21, topmost paragraph.
Okay. Yeah.
May I proceed, Your Lordship? Much obliged. Your Lordship, the aspect of vicarious liability which has been talked about in section 38, attributable to the neglect or connivance, can be... May I proceed, Your Lordship?
Yes, please.
Well, Your Lordship, if the director were to contend that he did not have any knowledge, negligence on his part is res ipsa loquitur. It is apparent on the face of it that if an offence of exceeding the legally permissible limits has been committed, such offence prima facie shows that there has been a negligence that has been committed by Mr. D'Souza, and that there was indeed.
There is a distinction between knowledge
Sorry.
and negligence,
Yes.
right? Now, how do you define what you say there has been negligence? How do you define his negligence?
Your Lordship, there are, as the knowledge of the Council, there is a duty of care, and when that duty of care has a breach, that you have breached your duty of care, that is
What
when.
is the standard of care?
Sorry, Your Lordship.
What is the standard of care you're expected to perform?
Your Lordship, the standard of care that has been expected is also given through the fact
It
of.
is a very common concept. Reasonable man of his average intelligence.
Indeed, Your Lordship.
52 of the Indian Penal Code defines good faith. What is not done? Anything which is not done with due care and attention. That is negligence.
Indeed.
And what is the test? Test is reasonable man, prudent man. So as a prudent officer of the company, what is his duty? Legal duty.
Your Lordship, the legal duty that Mr. D'Souza had was to ensure that the administration of ships is done smoothly, and that all compliances, all the legal compliances that even learned counsel for petitioners have submitted, that they had all the licenses. Your Lordship, the due diligence and the duty of care does not only extend to the point of having such license, but also ensuring that it is complied with, Your Lordship. If Your Lordship may allow me to use an example.
Yes.
To obtain a driving license, the person cannot say that I have a driving license and therefore I am allowed to drive at the speed of 180 when the speed limit is 60. Your Lordship, the due diligence and duty of care when negligent driving is also being discussed is that it's not that I have a license. It is that after having a license, I have versus State of Rajasthan, which is also a case under the NDPS Act, Your Lordships. Mohanlal versus State of Rajasthan, that Your Lordships may find on page 23 of the compendium.
23.
Yes, Your Lordship. The compendium, Your Lordship.
Yes.
The one with the flags. Much obliged.
Page 1.
23.
23, Your Lordship.
Yes.
May I proceed? Your Lordships, the pink highlight in that
A
says-
person.
Sorry?
A person.
A person, yes. A person who, although not in actual possession, knowingly has the power and intent, which says that DIR 12 form has to be filed, and that is derivative from the word shall in the rules, Your Lordship. And shall says that the legislative intent is such that it is a mandatory procedural formality. Further, Your Lordships, it is true that the DIR 12 form in compliance will also be dealt with separately under the Companies Act, where under section 172 there are penalties imposed on the company. However, herein the person cannot be construed to not be a director when the person is still a director in the public eye. His resignation has not been tendered. Your Lordship, further to
You have just uttered that his resignation has not been tendered. Accept it. He tendered the resignation,
Tender
but
he
not
has
accepted.
done, but
But not
acceptance-
accepted.
apologies, Your Lordship, that was a slip of tongue on
Many
my
times.
part. Much
But
obliged.
confidence which you shown.
Time is running away, she knows it. So what is it? Finally, quick, very quick.
Indeed.
Conclusion.
Your Lordship, in this matter, when the resignation is not tendered, he is
Not
still
tendered, it has been tendered, not accepted.
Accepted. The procedural compliances, apologies, Your Lordship. When the procedural compliances have not been met with, the resignation cannot be considered to be effective. And in light of all the three aspects of his knowledge, his control, and his designation as a director, which is still there, Your Lordship, Mr. D'Souza is to be held liable under section 38 subclause 2 of the Act, Your Lordships. If Your Lordships have any other question,
No, I think
You cited a judgment of Rajasthan High Court.
indeed.
Can you please give the citation?
Mohanlal versus State of Rajasthan.
And it was a judgment by?
it was, I think, that electricity matter.
It was an NDPS matter.
NDPS.
It was delivered by Honorable Justice Maheshwari.
Your Lordship, it is
Your judgment.
It was not, I believe.
Yeah.
So the golden rule is, in a lighter vein, I'm giving you a hint. Whenever you are arguing a case, better take a case decided by His Lordship only. You will be all the very best.
It was a humble pleasure arguing before this court. Your Lordship.
Because more often than not, courts एकदम से चिल्ला के पूछती कहाँ से लाए आप? It's Lordship by only. You only, Lordship. All
Much
the best.
obliged, Your Lordship.
So this is a very secret trick of the trade, which has been shared with you by Honorable Madam.
Much obliged. It was a humble pleasure arguing
Very
before
well.
this.
Very good. Please.
Yeah, come.
एक एक बढ़ा दो सबको इज वेरी वेरी गुड अभी तो दूसरी साइड से भी आएंगे बहुत लेट हो गया
How much time does he have?
20 minutes
2-0. Yes, young man.
Greetings to the bench.
Give us an answer.
Your Lordship, the council would be contending on the issue number 3 as well as the issue number 4. Issue number 3 pertains to be whether the two of the directors are liable or not, Your Lordships. And the state, as the counsel for the respondent, we are saying that the two of the directors are liable, Your Lordships, under twofold. Firstly, that the directors are liable under section 38(1) of the OD Act, and secondly, that the directors had the knowledge of the offence being committed, Your Lordships. If Your Lordship please may refer to the page number 32 of the compendium that the council has provided, and the council wants to seek the apology again for the lack of resources to the Lordships. But the page 32, in the judgment of Sunil Bharti Mittal versus Central Bureau of Investigation, Your Lordships, in the para number 37, it has been stated that, however, at the same time, it is a cardinal principle of criminal jurisprudence that there is no vicarious liability unless the statute specifies so. Your Lordships, in here, the council tends his arguments in twofold basis. Firstly, that there is an express statute provided under the relevant act, and secondly, there is an attribute to criminality of the directors which the council would be sufficing, Your Lordships. Lordships, if we read or the council may say the verbatim of section 38, it says that when
Section
an offence
38 of.
UDR, apologies.
Always mention the act, not just act number. Whatever is going on in your mind, we are not reading your mind. Please.
Note taken. Section 38 of the AOD Act, one says where an offence under Chapter 4 has been committed by a company, every person who at the time of the offence was committed was in charge of. Your Lordships, you have to see the words in charge of, and the words in charge of has been discussed in the state of Karnataka versus Pratap Chandra Rathod and others very evidently, Your Lordships. And according to the judgment, Your Lordships, on the page number 37 of the compendium that has been provided, it explicitly states that in charge must mean that person should be in overall control of the day-to-day business of the company or the firm, Your Lordships. And reiterating the para number 3 of the Moot preposition, both the directors as well as Mr. D'Souza were the only three signing authorities of what would be produced and what would be distributed by the firm, Your Lordships, thus stating their in-charge role as on the company's day-to-day affairs, Your Lordships. And by being the board of the directors, they had the power to authorize and approve the production, distribution of the stocks of pharmaceuticals, as well as the decision-making power vested within the directors reflect their position to be of the nature that they were the in-charge of the company, Your Lordships. And secondly, the council wants to contend on the facts that the directors had the knowledge of the offence. Your Lordships, first of all, before council proves his facts and his case, council wants to contend on the statements and the submissions given by the learned counsel for the petition. Lordships, they said that they were on the grounds of medical exceptions, Your Lordships. Lordship, if you may please refer to the section 8 of the AOD Act. On the proviso of subsection C that they refer, Your Lordship, it explicitly states that the provision imposes any requirement by the way of license, permit or authorization, also in accordance with the terms and the conditions of such license, permits or authorizations, Your Lordships. Your Lordships, as the example was given by my co-counsel of obtaining a driving license, Your Lordships, and as per Your Lordships have reviewed the notification given by the Ministry of Finance and the Department of Revenue, where they have clearly stated the commercial quantities. And if Your Lordships please may refer to the quantities that were given in the notification. It's on the last pages of the compendium, Lordship, on the page number 66 of the compendium, with the paragraph number 8 of the preposition, Your Lordship. And if we match the notification and the preposition of the facts of the case that are given, Lordship, the cocaine, which is methyl ester benzoyl, is required to be, the commercial quantity is 100 grams only, Your Lordship. Whereas the cargo which was carrying the commercial quantity was exceeding it by 400 grams, Your Lordships.
500 grams. It was 500 grams.
Yes, Your Lordships. And Your Lordships, when you obtain a license, it does not mean that you can carry the load at whatever capacity the person wants. It should be under the legal limit that has been set by the center government or any authority that is setting the legal requirements, Your Lordship. And thus, they are in contentions to the law, Your Lordships. Second, Your Lordships, if the council may reiterate the section number 23 of the AOD Act, it states that punishment for illegal imports to India, exports from India, or the transshipment of narcotic drug and psychotropic substance, whoever in contravention of any provisions of this act or any rule or order made or conditions or of license or permit granted or certification of authorization issued thereunder imports into India or exports from India, Your Lordships, and thus clearly having a culpability, Your Lordships. And now the council wants to submit his arguments in relation to whether the directors had the knowledge in relation to the report that or the notification that was given by the Ministry of Finance as well as Department of Revenue, Lordships. In further, there is a test known as control test, Your Lordships, and it was devised and given under Pooja Ravindra Devsnani versus State of Maharashtra, Your Lordships. Your Lordships, control test meant that directors, just because of the name that they were holding of directors in a company, cannot be held liable, Your Lordships. And if you have to hold a liability to a director, you should prove that they were in charge of the affairs, or they were in charge as per the provision number 2, the provision of the 38, that they had the knowledge as well as they were in charge of the act which made them liable, Your Lordships. And thus again the council wants to reiterate on the para number 3 of the proposition that made them the signing authority of whatever goes or whatever is produced by the company, Your Lordships. And thus they had the knowledge what was in the cargo being exported from the coast of Indices, Your Lordships. Your Lordship, there are two elements in here. First, the power to authorize the production and the distribution. And secondly, their position as the board of members having or making them in charge of the affairs of the company, and as per section 38, the word in charge is satisfied here, Your Lordships. If Your Lordships are content with the arguments given by the council in this issue, the council wants to move to the issue number 4, where the council establishes the liability of the company.
Please go ahead.
Much obliged. Your Lordship, the council wants to establish the liability on a company on two-fold basis, Your Lordships. Firstly, the SPVs, which are the subsidiary, are not a separate legal entity, Your Lordship. And secondly, the company is liable due to the doctrine of attribution and alter ego, Your Lordship. Apologies, Your Lordship. Your Lordship, the SPVs are not a separate legal entity because first, the nature or the extent of the control of the holding upon the subsidiary makes it liable, and secondly, the companies are too
inextricably linked entities, your lordships. And your lordships, if we reiterate the case of state of UP versus Renu Sagar Power and Co., if you please may refer to the page number 50 of the compendium provided by the council. Your lordships, on the very top of the page, the highlighted part, it is said that the corporate veil should be lifted where the associate companies are inextricably connected as to be in reality a part of one concern, your lordship. And even the petitioner has claimed in their submissions that just because of this company, the 40% of the total revenue of the company was incorporated, lordships. And secondly, lordships, the board of the directors of the holding company is the authority to appoint the board of the directors of the subsidiary company. And the third argument here is Mr. D'Souza being appointed as the administrator of the company is being decided by the board of the subsidiary company, the lordship, thus making them inextricably connected, as well as holding company having the control over the subsidiary company's management as well as the administration.
Which is the subsidiary company here?
Sorry, Your Lordship.
Which is the subsidiary company here?
Your Lordship, the SPVs are a part of subsidiary companies as per the fact.
It has not been argued by anyone. Not
Where
disclosed.
is it written?
Not
Where is it written the problem?
In the clarifications, Your Lordships.
That's a clarification.
Renu Sagar's case has been referred by the other side also,
Yes, Your Lordship. They have referred the
in this context only.
Sorry?
In the context of
apologies, Your Lordship. if you may.
in the context of SPVs, they have referred this Renu Sagar's case.
Certainly, Your Lordship, they have referred as the corporate veil being lifted, Your Lordships. They were contending that as the directors of the company is not liable, the corporate veil, if lifted, they will so nobody will be liable. But here, that we are contending is the corporate veil should be lifted because the directors were first made liable because in charge of, and as well as 38 states, if I may read. Just some that was responsible to the company for the conduct of the business of the company as well as the company shall be deemed to be guilty of the offence, Your Lordships. And thus we are implicating and responding to the SLP filed by the petitioner, Your Lordships. And Your Lordships, now coming to the doctrine of attribution and alter ego, Your Lordships. Even though the company, that is subsidiary and the holding, are considered to be a separate legal entity, distinct legal personalities, the corporate veil can be pierced to ascertain liability of act to prevent the injustice. If Your Lordship please may refer to the last page of the compendium, the councils have provided a corporate structure, Your Lordships. It's in this manner, Your Lordships. Firstly, there is the holding company which is run by Fleckingo and Flemingo Private Limited, which is run by the two directors. And directly under that company and under the company's ambit as well as powers is the special purpose vehicles whose affairs are being controlled by the same company, Your Lordships. And Your Lordships, if you may please allow the council to reiterate the Life Insurance Corporation of India versus Escort Limited, it was said in that case, Your Lordships, that the doctrine of corporate veil was laid down to include fraud, evasion of legal obligations, alter ego and tax evasion to be reasonable grounds for piercing the corporate veil, Your Lordships. In this, the first thing, that is evasion of legal obligation, every person has, as Your Lordships has just said, that the reasonable test of general prudent man has to be taken into account, Your Lordships. Firstly, there was high quantities or the quantities more than the notification has stated, and secondly, there is the doctrine of alter ego, which has also been stated in the case of Sunil Bharti Mittal versus Central Bureau of Investigation, Your Lordship, where the criminal intent of the persons controlling the company is copy pasted to the company itself, Your Lordships. And Your Lordships, in the case of Iridium Indian Telecom Limited versus Motorola, if Your Lordships may please refer to the page number 62 of the compendium, or if the council may state the exact verbatim of the. If your council may state, Your Lordship may approve the council stating the exact verbatim of the para 36 of the said judgment. Lordship, it says that in other words, the criminal intent of the alter ego of the company or the body corporate is that the person of the group that guides the business of the company would be imputed to the corporation. Thus, the mens rea that has been established by the council in the case of the two of the directors is to be incorporated to the will of the company and lordships. If your lordships are content with the arguments presented in relation to issue number 4, the council wants to proceed to the prayer, lordships.
Where we know? Where we know?
Much of
So you want to convey mens rea.
apologies. Your Lordship.
The important ingredient in mens rea.
Yes, sir. The criminal intent behind this, as well as being in charge of the acts which has been done in lordships. It was a pleasure to argue before this court, lordships. Thank you for the opportunity.
Thank you very much.
You want to say something in rebuttal? Yes, please. How much is the time allowed for this?
4 minutes?
14 minutes.
Huh? 4 minutes.
4 minutes to them.
Ajab.
And if they want, 3 minutes.
Lordship, our department, the jurisdiction of excise department is limited.
Haven't you gone through these clarifications given for the final round? They say that all the legal compliances were made, all the procedures were made as per the legal provisions. But no point remains thereafter.
Lordship, we are
You have got only 4 minutes to say, so please be concise
yes,
on your
yes, Lordship.
points which are really valid.
Lordship, the very first argument of our for contention is that the going through insolvency process, immediately he resigned from his post because he was aware about the law that if any person is going through any insolvency, he cannot be given the responsibility of directorship. This shows the innocence and conduct on the part of Mr. D'Souza. Lastly, Lordship, we are a pharmaceutical company dealing with the manufacturing and selling of pharmaceutical substances, and we should be given the medical exception under section 8 of section 8C of NDPS Act. With this, I rest my.
Yes, you have already narrated your previous statement. No new point have been added by you in response to their arguments. In rebuttal, you should have narrated the points raised by them. How do you want to rebut them? But whatever you have stated in your next phase of argument is the same which has already been mentioned by you in the earlier part. Thank you.
Your Lordships, the authority or jurisdiction. If I may please draw your attention to section 41 subclause 2 of the AOD Act. The very first line of section 41 subclause 2 says that any such officers of the departments of central excise, your lordships. The jurisdiction to the department of central excise and authority has been granted, and therefore inspector could have done the search and
Which
seizure.
one?
Secondly, your lordship,
Which provision are you referring to?
41 subclause 2 NDPS Act. your
All right.
lordship.
Yeah.
That any such officers of the gazetted rank of the departments of central excise can authorize, and subsequently towards the last 3 lines of the same section, anyone above the rank of a peon, sepoy or constable can arrest such a person. So the inspector who is above such ranks has the power and authority under section 41 subclause 2 to arrest. Secondly, your lordships, about the medical exemption. Medical exemption is there, but it is about the prohibition. Your lordship, such exemption is also subject to all the licenses and permits that are to be adhered to, and section 23 clearly, section 23 of the AOD Act, apologies your lordship, the NDPS clearly talks about contravention of any provision, license or permit granted. So the offence is not that you did not have a license, it is that you have acted in contravention. Thirdly, your lordship, to clarify the rebuttal that we have relied on their CIRP process, as has already been submitted by the council that it is an ancillary argument. to further substantiate his negligence. The first aspect is his duty of care with regards to the procedural compliances. Fourthly, to answer their aspect of DIR 12 form, the duty of the company and the aspect of shall. The theory of substantial compliance is applicable in this present matter, wherein the courts have opined that if the core objective of the statute is not fulfilled, you cannot go against the procedural errors. Your Lordship, the core objective herein is resignation of the director, and if such compliance has not been met with, such substantial compliance has not been met with, his resignation cannot be considered to be effective. With that, the council rests the arguments for surreptitious.
Okay.
It was the humble
Thank
pleasure of
you.
the council.
हमने टोटल किया तो है, चेक कर लेना। हो सकता है कुछ ऊपर नीचे।
कुछ तो करोगे आप।
अभी तो कर तो दिया, पर आप चेक कर लेना।
Thank you, sir. सिग्नेचर
सिग्नेचर करना है। अच्छा, पेन से नहीं करना है सर? नहीं, आई डोंट नो। put this
26, sir. Respondents 23.
हाँ हो जाएगा।
You have mentioned only
दीजिए
two
ना,
numbers. Which
सर
number
का
represents to which? 26 and 23.
यहाँ से उठे हैं, यहाँ से उठे हैं उनको।
हाँ, this girl is good. वो भी ठीक है, अभी अच्छे से उसको
सबसे बड़ी बात है कॉन्फिडेंस डेवलप होता है। Are you well? Both, not only one, both. मैं पहले आया था पिछली बार, तभी लड़के बहुत अच्छे थे।
There were 64 participating university. This is the stuff of final including all LLBs. There were 64. This is my personal copy.
20 professor like I told, but I क्या है
Basically, 30 minutes starting.
हाँ
Can we go to the washroom?
पर जो दूसरा वाले हैं
Yes.
जो practicalities पे जो जाती
She
है
wants to say something.
हाँ
She wants to say something.
मतलब
I request the honorable bench.
Hello, hello, hello.
I request the Honorable Bench to kindly pay attention. I request the Honorable Bench to be here only. I and other faculty members, even the director also, want to felicitate the members of the bench, the panel of the bench here only. So I would like to call upon Dr. I would like to call Dr. Akhil Kumar, Director UFYLC, to felicitate Ranka ma'am. वो वहाँ खड़ी है. Now I would like to I would like Shelly ma'am to felicitate Justice, Honorable Justice Deepak Maheshwari ji. I request Juhi ma'am Thank you, ma'am. Thank you, sir. I request Juhi ma'am to felicitate Now I request Juhi ma'am to felicitate Professor B.T. Kaul. Now I request Ranka sir to felicitate Now I request Ranka sir to felicitate Advocate Mahendra Shahaji. I again request Dr. Akhil Kumar, Director, to felicitate I request Dr. Akhil Kumar to felicitate Advocate Vivek Shrimali ji. I request Urmila Ranka ma'am to felicitate Now I request Urmila Ranka ma'am to felicitate Dr. Kamal Datta ma'am. It is a great honor to have all the dignitaries with us. We are truly grateful to one and all, to the dignitaries and to the audience. Thank you so much for being with us in the journey of our final rounds.